Welcome, everyone. Welcome to the lecture series on the right to research and copyright law. So the arc of our discussion so far has been to survey the great diversity of research exceptions, the human rights implications of copyright that unduly blocks research uses, the dynamics of the US fair use right, which has some of the features built into it that protect the kind of human rights to research that we spoke about, and then particular applications of exceptions to text and data mining research uses. And we talked both about some of the fair use cases and then also about the legislation in the EU. So today's lectures follow up on that. And we have with us Matt Sag, who's one of the US academics who really has done some of the earliest and continuous work on this topic. And in fact, in recognition to that, he's now a professor of law in artificial intelligence, machine learning, and data science at Emory University Law School. He's an expert on copyright generally, originally hails from Australia, but has been teaching in the US for a number of years. He's an authority on the fair use doctrine, and he's a particular authority on the application of fair use to text and data mining, machine learning, and artificial intelligence. And then we have Dr. Karis Craig, who's the academic corrector of the Osgood Professional Development LLM program in intellectual property law at Osgood Hall. And in 2018, she held the McCormick Research Fellowship at the University of Edinburgh. And as soon as she opens her mouth, you'll realize she's actually from Scotland. But today she's going to serve as one of our Canadian legal experts, among other issues. So Matt, thank you for joining us. As you know, a lot of your early work has been very much a formative influence on this project. And so we're really happy to feature that work within this lecture. So welcome, and thank you for coming.
I'm here to talk to you today about my 2019 paper, The New Legal Landscape for Text Mining and Machine Learning. This paper is one of a series of papers that really began in 2009 with an article that I wrote in the Northwestern Law Review about copyright and what I called copy-reliant technology. The heart of the paper is a discussion about text data mining. And so we should probably start with a discussion of what is text data mining. Text data mining, technically, you could say it's a computational process for applying structure to unstructured data. It's a way of turning things like books, movies, poems, social media posts into data that is more abstract than the original works. Text data mining is the technology that makes natural language processing possible. It makes internet search possible. It makes plagiarism detection possible. More recently, it underpins the Google book search that allows you to search inside printed books. And it is, of course, at the heart of most applications of machine learning and artificial intelligence. When you see something like DALL-E 2 or GPT-3 that's trained on an astonishing number of works, what those programs really are is they're a complicated statistical model built on abstractions from not thousands, not tens of thousands, but millions of copyrighted works. Now, what we can do with those abstractions is something we can talk about a little later. I want to talk to you briefly about why text data mining matters. And I think the best way to think about this is in three sort of conceptual buckets. Text data mining matters fundamentally because it's a technology that makes knowledge within works locatable. You can't know which internet website you want to go to until some software agent has crawled across that website and indexed the keywords and perhaps all the words within that website and then that information is run through a search engine. That process of playing websites is fundamentally an act of copying. And copying text is at the heart of all text data mining, which is why it's an interesting copyright question. But I just want to be clear, without text data mining, there's no internet search, there's no book search. So we could have a world of knowledge out there that we would have only very primitive means to discover without text data mining. We would rely on subject matter indexes. And if you're like me, you're old enough to remember the world before internet search, you will understand just how limited those kind of indexes were. I think even more importantly than that, text data mining enables us to generate new knowledge, not just to find existing knowledge, but to generate new knowledge about the relationships between works. So I think some of the most exciting work that's being done here is applications of the Happy Trust technology. Another fundamental application of text data mining is it lets us generate knowledge about groups of works. It lets us abstract from a body of works, understand the relationship between those works, and see general patterns and trends that emerge across those works. And that's really important for all kinds of areas of research. It's great for understanding literature and culture. It's great for spotting trends on social media. And it's also really significant in medical and scientific discoveries. Finally, we have, as I think is a distinct category, TDM being used as an input for machine learning tools that enable new creativity. And so I'm sure everyone in this virtual room is now familiar with DALL-E 2, the AI algorithm that turns your text prompts into images. That's just one example of a creative tool that's been built by machine learning, but at the heart of that machine learning is text data mining. And so all of this comes back to what I think is the most fundamental question for copyright law in the current era, and that's whether the protection of the author's original expression should stand as an obstacle to generating insights about that expression. The paper I'm presenting today has really two objectives. The first was to take stock of the legal issues impacting TDM in the wake of the Authors Guild cases. And the second was to sort of look forward and think about, other than the basic fair use issue that was resolved in the Authors Guild cases, what are the other legal issues that are going to be affecting particularly the research community using text data mining? In 2005, Google announced a fairly audacious plan to bring internet search to library books. Google formed a consortium or a coalition with a number of university libraries. It invented actually some new scanning technology, and then they went and scanned about 20 million library books. This process took several years, but pretty much as soon as it was started, Google was hit with a flurry of litigation. They were sued by the publishers, they were sued by some individual authors, and they were sued by several groups representing authors. And the most prominent of these groups is the Authors Guild. The Authors Guild sued Google using a class action format. And so the Authors Guild litigation, because of the class action format, started in 2005 and dragged on, I think, until 2016. So 11 years. There are two Authors Guild cases, though, because much, much later in the process, I think in around 2011 or 2012, the Authors Guild decided that it would be a good idea to sue not just Google, but to also sue the universities who were cooperating with Google. And those universities worked together under the umbrella of the Happy Trust. So the Authors Guild also sued Happy Trust, and that's why we have Authors Guild versus Happy Trust as one case and Authors Guild versus Google as another case. I think that the Authors Guild sued Happy Trust really as a way of obtaining leverage on Google without realizing that because of the procedural issues, the Happy Trust litigation could actually be resolved first. And that's exactly what happened. The judge who was assigned to hear the Happy Trust case thought it was interesting and important. He fast-tracked it. The procedural issues weren't so complicated. And he managed to resolve that case before the fair use question was decided in the Google Books litigation. So that's why there are two cases here, and that's why the Happy Trust case is really significant, because Judge Baird in the Southern District of New York, he was really the first person who got to opine, as a judge on whether copying millions of library books in order to generate metadata about those books should be legal or not. And quite thankful he decided that it should be legal. I think that the best way to understand the Authors Guild cases and to understand the legal issues surrounding text data mining in general is with respect to a concept that I call non-expressive use. My argument, which I developed in 2009 and then have repeated in a few other places, is that copyright fundamentally is about the protection of original expression. That if you look at the rights of the copyright owner, they are defined with respect to the communication of original expression to the public. And so if you look at a traditional fair use, like the Two Live Crews version of Pretty Woman, that was the heart of the Supreme Court's decision in Campbell versus Acuff Rose, there we see people using someone else's original expression, but only using part of it and putting it to a really different use that commented on and criticized the original. And that's why the court felt comfortable saying that is fair use. The use is transformative because it puts the work to a fundamentally different use. And so it doesn't really compete with the original expression of the original author. Non-expressive uses are a little bit like that, except the case for fair use is actually much clearer. A non-expressive use doesn't communicate the author's original expression to anyone, right? If you think about plagiarism detection, all the plagiarism detection algorithm tells you is that this book is 99% similar to this other book. That doesn't tell you anything about the original expression in the book. It's just an external observation about the relationship between the two books. Or think of a search engine result. A search engine result that tells you that here are 10 books that respond to your search query isn't conveying to you the original expression, the things that make those books copyrightable. It's just telling you some useful abstract information about those works. And so that's the kind of thing that I'm talking about when I talk about non-expressive uses. And I think fundamentally, non-expressive uses don't communicate the author's original expression, and therefore they don't substitute for that original expression. And therefore, they have a really strong claim to be considered as a use. Now, if you want to call non-expressive use like a subcategory of transformative use, I guess that's fine. If you want to think of it as a different category of fair use, I think that's probably a sensible way to think about it as well. I think in the United States, we're kind of trapped in the terminology of transformative use. And so non-expressive use is just going to be seen as a flavor of that. I think that this idea of non-expressive use has been influential. I think that if you read the digital humanities brief that I wrote along with Jason Schultz, who's now at NYU, and Matt Jockers, who's a digital humanities scholar, you can see in the judgment, echoes of the arguments that we made. You can see the judge referring to one of the examples that we use in our brief. You can see the judge kind of citing the same cases that we cite and following the logic of our brief. And you can also see that in some of the other Authors Guild decisions, but I think it's particularly clear in Authors Guild versus Happy Trust. So I think this concept of non-expressive use was actually quite influential. I should also say, this is such a good idea that I'm not the only person to have had this idea. I think if you look at Ed Lee's technological fair use article, there's a sort of similar suggestion in there. There on the screen here, you'll see a couple of other references. In particular, Abraham Drassenauer's book, What's Wrong with Copying, I think is, although it starts from a very different place, ends up at a very similar conclusion. I also think that you can see that this idea in my work has been quite influential on subsequent authors, and I just give a brief list here. If you're familiar with the fair use doctrine, you'll know that although it's been part of copyright law, arguably since about 1741, it was only codified in the US in the 1976 Copyright Act. And when Congress codified it, they referred to 4 factors that courts should consider in making their determination. And so if you look at the first factor, the purpose and character of the use, my argument is simply that non-expressive uses don't communicate the author's original expression to the public, and so they are quintessentially transformative. And quintessentially transformative is how the Second Circuit Court of Appeals described what was happening at Happy Trust in that litigation. It's easy to see why, when you convert text into metadata that is derived from the text, that it still is fundamentally different in purpose, character, expression, meaning, and message from the original works. And that's the test of transformativeness that the Supreme Court gave us in Campbell versus Acuff Rose. The relevance of commercial use under the first fair use factor is something that courts have struggled with. But if you read Campbell, it's quite clear that commercial use has no hard presumptive significance. The Supreme Court has recently confirmed this in Oracle versus Google. And if you think about it, if a use is non-expressive, then commerciality really shouldn't be relevant either way. A non-expressive use doesn't substitute for the author's original expression. And where there's no expressive substitution, it's hard to see how commerciality could really figure into the analysis. In terms of the second factor, the nature of the work, I think it's well recognized that the second factor as a factor is rarely dispositive. And you can look at Sony, for example, you can look at Campbell, for example. But I think the reason why it's rarely dispositive is that it's not really a factor. You need to consider the nature of the work in order to say something sensible about the other fair use factors. But I actually don't believe that it's an independent factor. And where the second factor is particularly relevant in terms of non-expressive use is that we have some copyright misfits, such as architectural works and computer software, that in some ways really don't belong in copyright because they are essentially functional. And I think you would need to apply this theory of non-expressive use quite carefully to computer software because it is functional, and therefore the idea-expression distinction doesn't exactly track in the same way. In terms of the third factor, the amount and substantiality of the portion used, this factor will generally favor non-expressive uses, even though non-expressive uses such as building a search engine running plagiarism detection, these all require copying the entirety of the work. The reason why the third factor will still favor these non-expressive uses is that complete copying is essential to analyze and index the works. And it's reasonable because even though you're copying the entire work for some internal computational process, you're not actually performing or displaying or communicating any of that original expression at the back end. You're not actually leaking out the author's original expression to the public, and therefore there is no possibility of expressive substitution. Finally, if you look at the fourth factor, I think it's pretty easy to see why text mining and other similar non-expressive uses don't have a cognizable market effect. If you think about an ordinary transformative use, here we're looking at something that incidentally communicates some of the author's original expression, but it does so for a different enough purpose that we don't think it's going to interfere with the rights of the original author. Well, a non-expressive use doesn't communicate the author's original expression at all. And so, a non-expressive use, because it's quintessentially transformative, has no market effect, even if it's performed by a commercial organization. As you might suspect, I have a lot more to say about this topic. In particular, there's the whole second half of the paper that looks at issues beyond non-expressive use and investigates other possible impediments to text mining research. So I talk about some contract law issues, I talk about computer fraud and abuse and the Digital Millennium Copyright Act, and some things like that. But I think this is a pretty good point to wrap up the presentation and leave some time for questions. So I'll do that.